Welcome to today's program titled Impact of Supreme Court's Fair Admissions Decisions on Employers and Diversity, Equity, Inclusion, and Belonging Initiatives. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Welcome everyone to this presentation on this really important topic in light of the recent decisions on fair admission decisions in universities. We have put together a terrific panel for you today, and I'd like to introduce them. We have Lauren Gozinski, who is a partner in our New York office, Christy Kiley, who is in our DC office, who is also a partner, and Christy Iacopetta, who is also in our New York City office. We have put together this panel of really thought leaders who have spent a lot of time pouring into the decisions, evaluating the impact that many employers are thinking about and trying to understand, in particular with regard to their own diversity, equity, inclusion, and belonging programs. So there's been an incredible amount of time and attention. The panelists are deeply involved on OFCCP, issues with regard to the executive order, diversity, equity, and inclusion, and counseling on these issues. So we are thrilled to be presenting them. I am going to be jumping off in just a moment and going to field comments. I guess I should have mentioned, sorry about that. For those that don't know me, my name's Annette Timon, and I chair our People Analytics Practice Group and do a significant amount of work in this space. So this is the road ahead, today's agenda. We're going to give you a background in the ruling on the fair admissions cases. We'll then talk about affirmative action in employment, and then we're going to focus really on the impact to employers and in particular on their diversity, inclusion, and belonging initiatives, and then wrap up with some practical takeaways. We know that there's a lot of interest and focus, so we are also going to be hosting a series of additional webinars that are going to come up specifically on various DE&I strategies and programs that we often see, and talk about it in the context of the cases and what we might be seeing, as well as we had presented an opportunity to engage in roundtable discussions. So we're in the planning stages of all of those. If you have previously provided an interest or demonstrated interest on that, we will be reaching back out to you all. So with that, I'm going to turn it over to our first presenter, Christy Kiley.
Great, thanks so much, Annette. And I will just echo her appreciation for all of you being here with us today to talk about what's not only just a really important social issue, but a fascinating intellectual one as well. We were talking about it before the call. There's just so much going on and so much to unpack with these decisions. We are going to start with a little bit of background on what led up to these cases, because it's a very important part of the context in terms of understanding where the court landed today. What we've tried to do is anticipate your most common questions, those burning questions we've been getting from our clients since these decisions came out, and hopefully make it really practical and useful for you when you go away from this call. So with that said, where does all of this come from, right? It didn't evolve in a background. Both Chief Justice Roberts and Justice Thomas spent pages and pages, dozens of pages, going through the history of civil rights law in the United States, the history of race-conscious decision-making in voting, employment, housing, all kinds of different things. And they really talk about the evolution of how all this has occurred in America. Because we started back in the 1800s, when African Americans were ruled to be property and not even citizens of this country, and evolved from there, right? We went through the Jim Crow era, we went through civil rights, and then we've come forward in time to reach the places we are now with the executive order, Title VII, Title VI, the Equal Protection Clause, all of these protections now in place to try and address some of the racial dynamics that our country was dealing with at the time. So all of that is in the background of this decision, and it's very relevant to where the justices view us today, especially because some of the justices, particularly Justice Thomas, are originalist thinkers. So they put themselves back in the mind of the framers of the Constitution and what they were thinking at the time. So just keep that in mind. All of that is at play here. The main issues that come out of the case are these that are listed here, right? Ultimately, the question is whether the school's policies, which we're going to describe in more detail in just a second, whether considering race as part of admitting students to colleges, whether it survives the highest level of review a court can provide, which is strict scrutiny. And to do that, it has to support a compelling government interest, and it has to do so in a narrowly tailored way. So the legal framework is really those two legal issues. And then there's a couple sub-issues that the justices talk about in reaching those ultimate conclusions. One of which is, if you have a compelling interest, first off, is it compelling? And second of all, is it something that can be measured? Is it something you can even tell when you've achieved it or not? And if not, how do you know whether the program is narrowly tailored? Is it unnecessarily, disadvantaging other races? Particularly in what they call a zero-sum game, where if one person gets the benefit, another person doesn't. And then is there a race-neutral option that would work just as well to make maybe these decision processes unnecessary? So that's really what was at stake in this opinion. It does build off of, as I said, some historical law. I mention these only because if you read the opinion or read the various blogs out there, you will see a reference to these two particular cases. In Bakke versus Regents of University of California, there was a white candidate for school who was denied admission, and the key part of that holding there, well, first off, there was no main holding. There were 6 individual opinions written. Justice Powell's opinion ended up becoming the sort of defining one of that time. And what he ultimately said is you cannot have a race-based quota where you have a certain number of folks who are definitely coming in, but you may consider race to some degree. So that was sort of the baseline, I guess, if you will, of where this current discussion started. And then fast forward to 2003, the court adopted Justice Powell's reasoning and made it clear that that was in fact the view of the Supreme Court, not just one justice. And they went on to articulate in more detail that strict scrutiny review that I outlined at the very beginning. So there's been a progression. There has been decades and decades of precedent in this area, right, building up to where we got today. And one of the most quoted pieces is this quote from Justice O'Connor. This was in the Grutter versus Bollinger decision. And she said at that time that she hoped that in 25 years, the use of racial preferences would no longer be necessary. So they were speaking to the context at that time. They ruled that yes, race-conscious decisions were still necessary in 2003, but Justice O'Connor at least hoped it would no longer be the case in 25 years. And those of you doing the math in your head, 25 years is 2028, which is not all that far away suddenly. And I don't think that Justice O'Connor's premonition is going to come true by that point. So that sort of leads us to where we are here. Another case that was very important was a Fisher case. This again was a white candidate who was rejected from the University of Texas, sued contending that the school's policy was unconstitutional and unlawful. It bounced back and forth between the appellate courts and the lower courts. But what's really important here is the Supreme Court explicitly acknowledged that the educational benefits that flow from having a diverse student body and a student body consisting of all kinds of different backgrounds and perspectives and people, that did satisfy strict scrutiny, that was important enough to satisfy that strict constitutional standard, right? And the goals that they said it advances for, educational diversity are these things that are in blue, right? Trying to increase understanding, get students a better concept of what's going on, and so forth. So obviously that debate continues today in our country. We have a lot of racial tension, gender-based tension, but views on different sides of the spectrums. That's playing into all of this, especially for you as employers who are dealing with questions from various stakeholders, employees, and so forth. And there's a lot that needs to be balanced here from all kinds of different influences and sources, right? Not an easy position to be in. Now, these two cases specifically were brought by a nonprofit group called Students for Fair Admissions, and they brought lawsuits against both Harvard and UNC at the same time. What's interesting there is that Harvard is a private institution, so it is not governed by the Constitution. UNC is a public school that takes federal funds, so it was. So you'll see in the opinions discussions of both Title VI, which is the school-based counterpart kind of to Title VII that we deal with in employment law, and then Equal Protection Clause as well, which says there shall be equal protection under the laws for all people, right? So the contention was that the school's policies violate both of those principles. Both of the schools, they looked at race in slightly different ways. In Harvard, it was part of a person's rating that they got a numerical rating. At UNC, it was considered a plus factor, something considered as part of the individual, but both stressed that it was part of an overall holistic review. So it's not the race was determinative, but they did admit to and explicitly factor it into their decision-making process. And the issue was that okay? Both of the schools claimed that it was because it's enhanced that important, compelling interest of a diverse student body. They were not making decisions exclusively on race, as might constitute a quota and, violate precedent in that area. And so the ultimate question for the court really was, in today's climate, given the law as it is, given the fact that these two schools put together, did it in fact survive strict scrutiny? Both of these laws, as I already kind of outlined these, they essentially prohibit discrimination in any decision-making process. And the justice's opinion, Chief Justice Roberts, he talks almost exclusively about the Equal Protection Clause. I think he talks about Title VI in one footnote. Justice Gorsuch, in his concurrence, talks about Title VII, but basically they just collapsed it all into one inquiry and said if it violates one, it violates the other. What did the court rule? We all know by now, right? The court did rule that these policies are in fact unconstitutional and violate Title VI of the Civil Rights Act of 1964 because they allow racial preferences or race-conscious decisions to be made. It was a pretty strong vote. It was 6 justices in favor, and each time Justice Jackson, you'll see the counts different there, 6-2, 6-3. Justice Jackson recused herself from the Harvard opinion because she went to Harvard and was on their board and so forth. But she did join for UNC. So there were a lot of reasons the court held against this, which we'll talk about very briefly here, but I've included a quote from Chief Justice Roberts that kind of summarizes it all. At its core, what it came down to was he was very troubled by the fact that there's no way to measure this, and I'm using his sort of supposed interest in educational diversity and the value of that. There's no way to measure it. It's very amorphous as a concept, and he was very troubled by the fact that there's no way to tell when it's achieved, right? The school said, well, we're trying not to have fewer minorities than we did last year. That was Harvard's goal. UNC said we want our Black population to be, comparable to that in North Carolina at large. So they did have some type of goal there, but these interests being advanced were just very sort of vague and hard to pin down, and that's something he took a lot of issue with. Another problem he had was that he felt these policies necessarily relied on stereotyping because it assumed that all persons of a Black race or all persons of a white race necessarily have something in common with their experiences, and that's not true. And several of the opinions talk about the difference between, for instance, an affluent Black candidate from Manhattan and a white candidate from perhaps Appalachia who as the first going to school in their family, and is it really fair to apply sort of those race-based assumptions in that instance? So it's a really interesting holding there. This is, again, kind of what I was just talking about here. He also was troubled by the fact that it is that zero-sum game. If somebody is a candidate and gets in, somebody else is being excluded. So race in this instance was being used not just as a positive, but as a negative, is what the opinion said, and that was very troubling as well. And then the lack of a logical endpoint, the lack of any ability to definitively prove connection between the two. So that outlines where the cases are, sort of the main issues, and I'm going to go ahead and turn it over to our other Christy Iacopetta, and she's going to talk to you about how this affects, if it does, affirmative action in employment. Actually, I'm sorry, you're going to lay the stage first, and then we're going to talk about how it affects it.
Yeah, I'm not going to steal your show. All right, great. So affirmative action in employment is different than it is in the educational context. We use the same affirmative action term as they do in college admissions, but they mean different things. In the employment context, consideration of race or protected categories or protected traits in any decision-making is strictly prohibited. In this space, there are a number of different laws that prohibit discrimination on the basis of different types of protected categories, but the one that we're really going to focus on today is Title VII, not Title VI. So if I accidentally say Title VII, actually say Title VI, that's the educational context, Title VII, employment context. Title VII of the Civil Rights Act, and again, that prohibits discrimination on the basis of race, color, religion, sex, and national origin. So again, under Title VII, consideration of race or other protected categories in employment decision-making is unlawful, except in very narrow circumstances to correct manifest imbalance. So I'll look here. And so in 1979, the Supreme Court laid out that framework for us for those very narrow circumstances where race can be considered or gender can be considered. And that case is the United Steelworkers of America versus Weber. In Weber here, a white male challenged his company's policies of selecting trainees based on their seniority, but also requiring that at least 50% of the trainees were Black. So Weber claimed that the policy was discriminatory in violation of Title VII because he was not selected for the program, despite having more seniority than some of the others that were selected. And so the court there held that the consideration of protected traits in employment decisions is lawful under Title VII, but only if the employer can establish three things. One is that there's a demonstrated and statistical manifest imbalance between traditionally segregated or underrepresented groups, and that manifest imbalance must be evidenced by some appropriately structured statistical analysis, right? You can't just say there's an imbalance. The second item is that the measures that are implemented have to be narrowly tailored and not unnecessarily trammel on the rights of others. So for example, if there's a demonstrated imbalance, employers may not implement a hiring quota because that would trammel the rights of others. And then the last piece is that the program must be temporary and limited in duration. And that means that the efforts and the results have to be monitored over time so that once the imbalance is remedied or corrected, that affirmative action measures that you implemented must stop at that point. So it's important to note that this is a very limited exception, and employers are using this standard pretty sparingly. Most employers are not making race and gender-based decisions, but if you are considering doing so, be very careful, especially in light of this recent decision. And moving on here, around the same time of the Weber decision, the EEOC also issued guidelines on voluntary affirmative action, and they largely follow the Weber case law. The guidelines say that affirmative action is not a type of discrimination, but a justification for a policy or practice based on race, sex, or national origin. So it's like an affirmative defense, where an employer could say, yes, race played a part in the decision-making process, but the affirmative action plan is the justification for it, assuming that the affirmative action plan was properly established. And so under the EEOC guidelines, they say that affirmative action is permitted if an analysis reveals that adverse impact and that the impact was caused by an existing policy or practice, if it's to correct the effects of past discrimination or to address an artificially limited labor pool. But affirmative action under these guidelines still requires a three-step process, or the 3 R's of reasonableness. The first is a reasonable self-analysis to determine whether your practices have a limited or excluding employment opportunities for women or minorities. An example of that type of analysis would be an adverse impact analysis. The second R is a reasonable basis for concluding that the affirmative action is appropriate. And then you also have to have reasonable action that's designed to achieve the purposes of Title VII and solve that problem that you identified when you did your reasonable self-analysis. The reasonable action must be temporary, and it must avoid unnecessary restrictions on opportunities for the workforce as a whole. So as you can see, it sounds very familiar to the Weber framework, but remember that this too is also a very limited exception to that general requirement in employment law that employment decisions must be made without regard to race or gender or any other protected category. Also keep in mind that these types of actions really aren't the same, the types of actions where we're making decisions based on race and gender aren't the same as those that most employers have as part of their DEI initiatives. Again, most employers are not making race or gender-based decisions, but rather they're focusing more on the outreach, recruitment, and training aspects of those programs. Okay. So in this context, we often hear the term reverse discrimination being used to refer to discrimination against a historically advantaged group, but there's really no such thing. Reverse discrimination is just discrimination, and the EEOC uses the same Title VII standards regardless of whether the impacted party is a member of a historically advantaged group or a historically disadvantaged group. Along those same lines, the Office of Federal Contract Compliance Programs, or the OFCCP, which is the federal agency within the Department of Labor that enforces the affirmative action requirements for federal contractors, they also will investigate potential discrimination regardless of who's being negatively impacted. So the agency will pursue claims where employment practices are negatively impacting white males. So in a nutshell, that's voluntary affirmative action in the employment context, but there's also mandatory affirmative action for some employers in the employment context as well. So employers who have direct contracts or subcontracts with the federal government have separate mandatory affirmative action obligations. Again, the Weber framework and the EEOC guidance on voluntary affirmative action that we just discussed, those apply to employers regardless of whether or not they're a federal contractor. These mandatory affirmative action obligations that I'm going to speak on for a second now, these are only for federal contractors and federal subcontractors. So in this context, for mandatory affirmative action for federal contractors, we're not talking about race or gender-based decision making. In fact, it's actually prohibited under the requirements enforced by the OFCCP. And as I mentioned before, the OFCCP is just the agency that's tasked with enforcing the affirmative action requirements. And they're found in 3 separate areas. The first is the Executive Order 11246 for women and minorities, Section 503 of the Rehab Act or the Rehabilitation Act, which is for individuals with disabilities, and then the one that I can never say, which is the Vietnam Era Veterans Readjustment Assistance Act, or VEVRA, which is for protected veterans. So under these requirements, federal contractors are specifically required to have non-discrimination policies and practices, and they're required to affirmatively evaluate their policies and practices to ensure that no particular race or gender or ethnicity is being negatively impacted by those policies or practices. And oftentimes that involves an analysis of the company's hiring, promotions, and terminations activity, as well as their pay practices. The affirmative action obligations also require an analysis to determine whether females and minorities are underrepresented in any of the contractor's workforce as when they're being compared against the available labor pool. So if there is a significant difference in that representation or significant underrepresentation, contractors are required to set placement goals and then engage in targeted diversity sourcing and outreach efforts in those areas where there's underrepresentation. So notice I didn't mention anything about race or gender-based decision-making, and that was on purpose because that's specifically prohibited in this context. Using a protected trait as a plus factor is prohibited as well. There's oftentimes some confusion about the concept of placement goals because people sometimes confuse them as quotas or set-asides, and that is not what placement goals are. In fact, in the affirmative action regulations, they expressly prohibit quotas or set-asides or any preferential treatment. The real purpose behind those goals is to encourage diversity outreach and recruitment. And the thought is that the more diverse candidates you attract to apply for your open positions, the more likely it is that those diverse candidates will be selected through your neutral selection process. So as you can see, it's affirmative action is a little bit different in the employment context, and it's a little bit different depending on which context within employment you're looking at. So with that, I will turn it over back to Christy to just talk through some of the impacts that we're thinking about based on these decisions.
Thanks so much, Christy, for setting that stage. So we've told you what the two opinions ruled, and Christy has told you what employers currently do and can do in the employment setting. So let's see how the two go together now. Where does this leave your business or your clients? Are you stuck between a rock and a hard place trying to satisfy two competing ideals and goals? Or is it just status quo, the same as it was yesterday? I'm going to say actually it's both for reasons that we'll talk about. I think it would be naive to say that this is not going to affect you or has not already affected you on a day-to-day basis. But as we'll explain, there is no direct, immediate legal impact that necessitates any change in anything employers are doing, especially because, as Christy mentioned, employers are already prohibited from making the type of race-conscious decisions that were at issue in these cases, right? So why does this not have any direct legal impact? That's where we're going to spend most of our time. There are, however, other areas where this does affect you. And in my calls with my clients, this is what I've been seeing, right? And any good business knows that there's a lot that goes into a decision. It's not just about legal risk. You have to balance reputational interests. You have to balance the interests of your leaders, concerns of your employees, what's actually manageable day to day, what you have a budget for. So all of those different things really do come into play. Most important, however, is the legal question. Why does this not affect what you as employers or your clients as employers are doing? The short answer is because it's completely different laws. So the Equal Protection Clause of the 14th Amendment and Title VI have very specific standards. They apply to government-related entities, right, either covered by the Constitution or those that receive federal assistance and funding, like grants and endowments to operate. Those laws do not apply in the employment setting, except in very limited instances where there's a direct tie between the federal funding being provided and the employment of that entity. The general matter, Title VI does not govern even those same entities from an employment perspective. Title VII was enacted to cover the employment angle of the civil rights issues, and Title VII controls in the event of any conflict between the two. So different laws, different standards. Employers already may not make the types of decisions that Harvard and UNC admittedly were. Okay, so the same issues are simply not at play. Even considering race as part of the process, you know, as any motivating factor, is problematic for employers, right? Again, though, that does not have any impact on your ability to encourage diversity, to embrace inclusion, to want a diverse workforce, to solicit and recruit from broad sources. None of that is impacted by these decisions. I think that's really important too, because the opinions, the dissenting opinions of Justices Sotomayor and Jackson are really, really impassioned and speak with a lot of concern about what this might mean for America, whether it's going to send America backwards in the progress that it's made from, a race relations perspective. And at least, we can take some comfort in the fact that for employment, that as of today is not the case, right? So if what you were doing was lawful before these decisions, it's still lawful now, right? That said, if you are a company that was sort of teetering on the line of debating whether to take some type of race conscious action, for instance, if you were wondering whether you should take the next step in your DEI goals or, making decisions coming up, this is a great time to maybe look at those with fresh eyes in light of what the court has expressed about sort of how hard it is to show these compelling interests that are tied to specific discrimination and making the showing that's required. So it might be a good opportunity to look at these policies, just again, take a fresh eye under the employment standards and make sure that you are on very solid footing with the principles that do apply, okay? The other thing to take note of is if this current Supreme Court term has taught us anything, it's that things can change dramatically with the right opinion. Dobbs certainly showed that. Cases certainly showed that. Decades of precedent can sort of go out the window and the law goes in the other direction. So all the Supreme Court needs is the right test case to come before it, and we could find ourselves in a different legal environment. So just be very cognizant of that, again, as you're going forward and evaluating your policies and principles. Nobody has a crystal ball. Nobody can tell if these cases are going to come before the court or how the court would rule, right? There are, however, some indicators that the current justices would be disfavorably inclined if they were confronted with things like the Weber analysis, which permits similar race-conscious decision-making in instances, like affirmative action and Executive Order 11246. So really only time will tell whether there will be any expansion of this, but there is some language in the dicta of the case that signal that has some potential. Here are some of the other considerations that I mentioned, right? And one of them has to do with messaging and understanding. It's really unfortunate in my mind that the educational context and the employer context both use the term affirmative action because that implies the concepts are the same. And as we've explained, they're really very, very different in the two different areas. So it's really understandable that people get confused by that. Employees are asking a lot of questions. Hey, our company has an affirmative action policy. Does that mean we're violating the law? Are we going to cut back and not support DEI anymore because of this decision? There's a lot of confusion around that, and that takes time and effort and consideration to respond to. You have to think about how your company is going to present to the media. There's just a whole array of other considerations that come into play here. And is it going to affect your diversity substantively? Are you going to have a less diverse pipeline coming out of the schools and therefore being available to you as employees? All of those things sort of remain to be determined in the future. The other thing, and this goes back to the rock and a hard place, is there is a tension there, right? So if on the one hand, an organization gets more conservative perhaps in what they're doing for DEI or wants to slow down or take a break, maybe that makes them feel more comfortable from a legal perspective, but then they're sending a mixed message about DEI and potentially causing problems in the other areas and dealing with employee morale issues and things like that. So it's a very, very difficult place to be in as an employer today, and we empathize with that and work with our clients on that all the time. It is not an easy subject to be making decisions in right now, but just know that you are not alone if that is something your organization is struggling with. Let's get a little bit more into specifics here of things that have and have not changed. As Christy mentioned, reaching out to diverse sources always has been hopefully always will be okay because it's not impacting decision making, right? It's when you cross that line to making a decision about someone's employment, either the opportunity to hire them or the decision to advance them once they're employed, that's when Title VII and the similar laws come into play, right? So where you see this line of permissible, impermissible, reasonable, unreasonable, that's really where the line gets drawn, is where you start making decisions. You can see on the right the types of things that are currently problematic. Again, not because of these two cases, before those cases, under the employment standards, problematic under the employment laws, certainly any type of quota or set aside. And these are the sorts of situations that are currently starting to bubble up in the district courts. We are seeing more cases based on DEI efforts. Things such as, a white employee who's let go and feels that it was because the company was trying to achieve some particular racial balance, or maybe somebody thinks they weren't hired for that same reason. We are starting to see litigation about those types of things. Whether that's factually what happened is a completely different issue, of course, but there's a perception at least that may be happening. And if that was the basis for the decision, it would be highly problematic. Again, this just goes to tangible employment action is where you start to have issues. Inclusion, belonging, diversity, all of those things as cultural values and opportunities are things that your organizations can and should continue to embrace. They are not impacted by this decision. They don't involve any type of zero-sum analysis where one person has to be disadvantaged because another person is getting some type of benefit, because that's not the situation in employment, right? So as long as you understand that framework, you need to march on. Here's just sort of a projection of the types of risk analysis that we're doing with our clients and things we're seeing. Again, creating a diverse culture is something that benefits everyone, and it doesn't call into play any of these employment standards we've been talking about. Mentorship and training, as long as it's in the mindset of sort of creating an embracing environment, helping people know they're supported, absolutely fine. Recruiting and sourcing from diverse sources, absolutely fine. It's at that decision stage, again, when somebody would advance in the process or drop out of a selection process because of a protected trait, that's when you start to run into challenges with the employment laws. But again, that's the case under existing law, not because of these fair admissions cases. So one of the takeaways we really want you to have from today is just thoughtfulness, right? These areas just require a lot of consideration and thought. And unfortunately, one of the things that needs to be considered is the fact that diversity metrics and statements, pronouncements, disclosures to the media, once it's out there in the public sphere, it can be sort of manipulated and used and messaged by other people in whatever manner they choose to do so. So you have to be really, really careful before you sort of let the horse out of the barn and you can't get it back in. Be really thoughtful about what diversity metrics you're generating, who they're shared with, what the purpose is, internal versus external, how they're controlled. All of those things are just incredibly important because they can end up be using against you if not, controlled and used the right way. Federal contractors are very familiar with this. They just went through the EEO-1 FOIA issue, and if you take an EEO-1 report, you can make a company look either favorably or negatively from a diversity standpoint using the exact same data just by focusing on different things. So it's just an example of how you need to be really careful with tangible sort of statements and documents and evidence that you may be generating. That said, I've emphasized that a lot of things stay the same, at least as of today. What is different? Well, I think the likelihood of a challenge against Weber, against affirmative action, against all these different types, I think the likelihood of it being challenged has gone up. I think these cases will embolden people who want to make challenges under those areas. There certainly are advocacy groups and nonprofit organizations who are extremely interested in these types of issues, who are looking at what employers are saying, looking at announcements on web pages and in newspapers and things like that. So the odds of us seeing this come to a head legally, I think, are greater than they were. The current court is probably not favorably inclined to the issue. If it takes a couple of years and we have a different justice or two, who knows? The history of this issue shows that it can be very political in nature, but the current court with those 6-2 and 6-3 rulings has sort of shown where it comes down. Be spending a lot more time on these issues. And again, there's tension around this. There are perfectly valid viewpoints in a lot of different ways on various diversity issues and DEI initiatives. And it can be hard sometimes to have measured discourse about it, but that's more important than ever now. And hopefully that will continue. Even if the conversations are hard, they should still be happening. DEI is more front and center now. There was a time not too long ago when DEI was sort of a behind the scenes function. Remember that? Well, now it's very much out there, and it's going to continue to be. It's not going to become less important anytime soon. And again, staying on top of the legal developments and paying attention to what's happening is absolutely the right thing to do, because all we can do is react to the laws we have at the time. Right? So you are absolutely doing the right thing by wondering about these cases, by wondering what to do, and by preparing for them. So that said, I'm going to turn it over to Lauren with some of our practical takeaways.
Well, we were already getting into some practical takeaways, and this is the portion of the program where certainly I invite my colleagues to chime in with their thoughts at any point. And really, it's one of the purposes of what Annette said earlier about why we're going to have other programs and roundtables and smaller things. We just have too many people on this today to really be incorporating everything you're asking and all your thoughts at once, although I know Annette's been hard at work. So if we had to, oops, I overshot. If we had to boil it down into a top five, and Christy was just repeating this, we can't repeat it enough. The affirmative action in the fair admissions case, it was very different than employment affirmative action. And so all of those immediate media mentions you saw of affirmative action is dead was an overstatement. Affirmative action can mean a lot of different things in a lot of different contexts, and it is not dead in every context. Right now, in the employment context, that decision did not change the legal landscape. If your DEI was lawful before, it's still lawful now. But when we start to, now we start to get to 4 and 5, we're certainly not saying, as Christy said, we're not saying that nothing has changed in the landscape as a result of the fair admissions decision, and indeed other legal decisions, and this anti-woke movement that's happening in certain jurisdictions around the country. The landscape has changed, and it continues to change. And with that in mind, unlawful or overly aggressive DEI efforts are now more likely to be challenged and thus present more legal risk. It's just the reality of the situation now. And you also need to expect lots of dialogue around this issue from your employees, from your stakeholders, your investors, your customers, you name it. So, when we get into what action should be taken immediately, an adage of outside counsel that may frustrate you on occasion, it depends, and there are no one-size-fit-all templates. Well, that adage is actually especially accurate here. How you decide, and in this slide we say decide, or it might be reassess how DEI fits into your corporate priorities and values. That's a very organizational specific issue. There is literally no other organization that is exactly the same as you in every aspect that could play on how you reassess the considerations here. Where are you on your DEI journey right now? Where you were thinking of going with it, how this might change what you're going to do there. Communication is a really important point on this. You could have the best intentions. You could even have a really great framework. But if you are not messaging in a way that makes people feel comfortable, you are much more likely to have challenges and discomfort. So I think it's important to note that your messages may be different internally versus externally. Starting with, starting with the managers who really need to understand what it is that they're going to be acting on. And you can go into different levels of detail at a certain point. And then this goes to the educate and train. And right, in the slide, we talk about educating and training leaders. I would say that there also is other training you can do, but for the training of leaders, it's really important to make them understand in the framework what's lawful versus what's not, what's consistent with your goals, and what's not. When we were preparing, we were talking about, and this was touched on earlier, our first teeter-totter slide that we went through earlier mentioned that maybe if you basically lessen certain of your DEI initiatives, maybe you'll decrease legal risk. I'm not so sure. There's a competing argument, and I read a quote from a law school professor that, are you really in more danger of facing claims from the historically privileged, or are you, the typical types of claims that we as the employer community have been worried about for years from the underrepresented? Is that still a greater concern for you? So bear that in mind, and don't necessarily overreact when thinking this through. This point about coordination is really important. We've unfortunately been presented with far too many situations where really the problem was that the client did not have the legal team integrated fully into what HR, talent recruiting, that the diversity teams were doing. Not everybody was rowing in the same direction. You can get much further, much more successfully if you ensure that everybody is rowing in the same direction. And those, I imagine, where legal and HR are heavily represented in this audience. This decision and the landscape around it give you more credence, more of an excuse for what you probably already been arguing, that I should be involved in more of the decision making and integrated into how that works. You really need to be now. And it's both Christies were talking about legal assessments, and including possibly doing statistical assessments in certain areas. But it's really, I think it was always a good idea, but this current landscape makes it an even more important that you conduct an in-depth legal assessment of your existing and your future, your proposed, your planned DEI initiatives. There might be some things that you were thinking of doing that you might want to hit pause and reevaluate before you act. And another thing I'll say is, I did see a question in the chat, and I understand it. We have a goal of increasing, women in this historically underrepresented area of the company, and we have two people equally qualified going for the position. We like both a lot. Is it then a problem to hire the woman? We understand that, but that's an easy way to think of the situation. The reality is that this is hard work, and that's kind of taking an easy way out. Well, they're really equal, so let's just go with, to fulfill our diversity goal. I think on the current landscape, you need to work harder and go deeper to come up with a real distinction between your final two candidates. so that you can truly argue you're choosing the best person for the role at that point. So the reality is that I think in some DEIB programs, there have been occasions where, because it's easier to reach a laudable goal, to kind of make some knee-jerk, simple preferences that you don't want to think are actually decisions, but they really are, getting to the point where you're factoring a protected class into the decision. I think in this landscape, that's dangerous, and you need to work harder to come up with a system where you can avoid that. And right with that, we're into more of the hard work. I think that the analyzing the specific current representational data, we've had some questions. Does this mean I shouldn't even be measuring things anymore? No. This does not mean that. It's fine to measure. It's important to measure. And in fact, the measurements can provide you with more context. But just because you're measuring and counting doesn't mean you're making unlawful decisions because of that. If you don't have the needed expertise in-house, you might need to reach out for it. Finding the why behind the what is a kind of a broader way of getting at what I was trying to speak to earlier, of going deeper in what you're looking for. And institutionalizing the culture. This goes back to the coordination between the groups within your organization. If you have some groups doing things one way and another group doing things another way within your organization, rather than truly making it something that is a fundamental part of what everybody is doing, you run more risk of some of those groups running afoul.
Hey, Lauren, I'm going to jump in on this one, if that's okay.
Of course.
Invited us to do so. This
Absolutely.
is where the bullet on find the why behind the what is so critically important. We do a lot of, analyses and support for whether it's a federal contractor or a private employer on these issues. And it's one thing to do the data and to do an analysis, but really structuring that analysis in a way that really gives you good insight about your organization is really, really important. So for example, if you're a federal contractor, taking the data and aligning it in a way that looks at, manager levels, perhaps by a specific organization, and then taking a deeper dive by organization or business unit, whatever you call it, right? And say, okay, what is the impact? What are the initiatives or the programs that perhaps my sales team might need based on the data and the information that's reflected there, as compared to perhaps my tech teams, right? The folks that are doing really high IT support, or the coders or the engineers. Are those programs the same? Are they different? How can I target them more specifically in terms of the initiatives that I'm doing? Because the needs are often very, very different. That's what this kind of be willing to do the hard work means in this context. The data gets you part of the way there, but you really don't know the why. And sometimes combining even your engagement surveys with the data that you're seeing and trying to align and get a better understanding by organization or business line, even by level within the organization, is really important. And that is the hard work. That is the deeper dive and going beyond the data and really listening and really building a very strategic, very focused DEIB type of program. So I just wanted to jump in on that, Lauren.
Oh, no, thanks, Annette. And one other area in this is some employers have relied on statements that they've made, goals that they've set, and they've gotten in some trouble. They've in fact had some challenges under the Trump administration. There were challenges, and there's still some private organizations. And you might want to think in terms of statements, that some of these statements that might look good might placate investors, might placate employees, but they might be hard to square with exactly where you are right now and how you're going to get to where you hope to go. Sometimes at this point, it might be better to actually focus more on the underlying hard work of getting there without overdoing the statements, because we're in an environment where the statements might cause you some trouble. And in terms of statements, hasty actions and reaction pronouncements, I get it. Some boards and some C-suite people were probably, we need to come out with a statement right after this decision. You might want to think carefully about how you handle that.
Lauren, I would just add too that I was looking through all of the comments as you were speaking. We have almost 100 excellent questions about really specific scenarios. Is it okay to do this? Is it okay to do that? I wish we could answer all of them because they really are great questions directly on point with what we're talking about. We obviously don't have the time to do that today, but hopefully the guidelines we're giving and your legal counsel can help you get to the specifics of those. Thank you for raising
And I know Annette's been working hard at answering some of them, at least while she could. And this slide, very briefly, inclusivity should be in the DEIB framework the least controversial, kind of the most welcoming part of it that you can really focus on and help everything else. But just to acknowledge the difficulty of the situation we're in, one of the other decisions that the Supreme Court decided just a day later, the 303 Creative LLC versus Alenis, I've been fielding counseling questions from basically certain employees are using a request for religious accommodation in a framework that some might view as non-inclusive towards their LGBTQ plus colleagues or others with whom the organization interacts. It's a complicated balancing, and you just need to be aware that even in the inclusivity area, there can be potential pitfalls. So,
Lauren, I'm going to add one here.
Sure.
With the CLE code.
Yes.
Code. Yeah, we didn't want to forget that. SS is in Seyfarth Shaw 2317. SS as in Seyfarth Shaw 2317. Go ahead, Lauren.
And in our precious little time, because I want to see if anybody else has any final thoughts, just focusing on that third bullet point for a minute, accentuate the positive, glass half full. We really believe this here. This is an opportunity to really refocus and think deeply and broadly about what you're doing and where you want to go in a way that can be constructive. And on the monitoring this area of the law closely, Christy referred to it earlier. In the slide, we say change may or may not. We can't guarantee it's going to happen. But if you look at, what Gorsuch's opinion, he talks about we should have decided all of this exactly the same under Title VI, and Title VI is the neighbor of Title VII. I mean, very clearly there are some justices who were thinking about and itching to make broader pronouncements that would spill into the employment area. So we do think that you should monitor closely because change very well may be coming. Any other final thoughts?
Yeah, Lauren, I was just going to build off that and say, as a takeaway, don't abandon ship. Those of you who are really committed to DEI and believe in it for your organization, you can continue to do so, and you should continue to do so. Nothing about this undermines the value of those principles. I think what this decision does more than anything is acknowledge how hard this area is to address as an employer and how many competing tensions and influences you have. And it just makes it more important than ever to keep that dialogue open, keep your doors open, and continue to have those tough conversations. Anyone else?
I think that's a mic drop.
Finished right on time. That's always good.
Well, thank you everyone for joining us for the session. There's going to be additional, as I previewed, right? There's more that we are doing. There's an incredible amount of work. I'd like to thank the panelists for all their time and their hard work on doing this, and for all of your thoughtful questions. We'll actually take those. I did my best to answer as many of them as I could. There were a lot coming in, but I did do my best. We'll take those and we'll incorporate them and build additional programming and additional materials. That is our hope, to be able to do that. This is a very important topic for us and just in general, and so we appreciate all the time and the attention that you've had and spending the last hour with us. Thank you so much.